Good afternoon. I'm Rick Simchak, and I'm a partner with Plunkett Cooney's Torts Litigation Practice Group. I also serve as coordinator of the group's webinar programming. Today, it's my pleasure to serve as the moderator for our discussion. So let me begin by welcoming everyone. Today's webinar will focus on defending one of the more difficult types of claims, those involving alleged traumatic brain injuries, particularly those not verifiable with today's medical diagnostic tools. Before we get started, I do want to take just a few moments to provide you with some background about our law firm. For those of you who don't know, Plunkett Cooney is headquartered in southeastern Michigan and is one of Midwest's oldest and most respected law firms, with approximately 130 attorneys in 7 offices across Michigan, as well as locations in Chicago, Columbus, and Indianapolis. Plunkett Cooney's Torts and Litigation Practice Group is comprised of attorneys across the Midwest who focus their practices on various aspects of general liability, retail liability, premises liability, dram shop, and other related areas of litigation. Leading today's discussion are 2 other members of the Plunkett Cooney Torts and Litigation Practice Group. Alicia Hester from our Bloomfield Hills, Michigan office, Alyssa Kennedy from our Petoskey, Michigan office, and today we're joined by Dr. Kristen Schutte, a neuropsychologist affiliated with MedSource of Michigan. Alicia is a member of our firm's Tort Litigation Practice Group. She represents clients in the areas of general litigation defense, including product, premises, and motor vehicle liability. She serves as defense panel counsel to some of the nation's largest insurance carriers, and her work involves catastrophic injury claims, including closed head injuries. Alicia has been named a best lawyer in America and a Michigan super lawyer. Alyssa maintains a busy litigation defense practice in our Petoskey office. She has experience in such areas as general liability, medical liability, toxic torts, premises, nursing home liability, and transportation law. Alyssa is admitted to practice in both Michigan and Ohio, and she has the distinction of being named a rising star in the area of medical malpractice defense by Michigan Super Lawyers magazine. Dr. Schutte is a well-known and well-respected neuropsychologist, a graduate of Central Michigan University, a licensed psychologist, board certified in that discipline, and affiliated with Corewell Health. And just a couple of quick notes about myself. I'm a partner with Plunkett Cooney, and I have been practicing for 46 years now, with 30 of those years spent right here at Plunkett Cooney. My litigation practice is diverse and includes claims involving premises, insurance coverage, motor vehicle liability, title insurance, and commercial banking law. Now, before we get started, just a couple of housekeeping notes about today's program. First, you're invited to submit questions throughout today's program using the questions window on your GoToWebinar dashboard. At the end of the webinar, we will take as many questions as time permits. Secondly, today's session is being recorded, and that recording will be available on Plunkett Cooney's website, which is located at plunkettcooney.com. Once again, on behalf of our firm, thank you for attending today's webinar, and now let's get things started. Alicia, if you would, take it away.
Why is it so difficult to defend TBIs or traumatic brain injuries? This is because 1, they're controversial. They don't follow the normal diagnostic testing results. 1 could practically only need a doctor to say or diagnose it. 2, it's subtle. And 3rd, it is dangerous. It's dangerous because it takes so little to prove, and the proof can basically be as little as what the patient tells the doctor. All it takes is a patient telling a doctor in an exam what could be wrong. And it takes so little to convince a jury of the same. And why is it so serious? That explosive verdict. Some of you may recall in 1993, the $79 million verdict against Domino's Pizza. This occurred from a plaintiff's brain injury from brain shear diagnosis. Now imagine, if that was 30 years ago, what's the present risk presented by such a claim today? And in actuality, we've seen lately some very large verdicts, over $100 million, coming out of our Tri-County Circuit Courts. Further, some of you may be aware that the cap on non-economic damages in med-mal cases may be going away soon. So stay tuned to our legislation to decide or see how that goes. So where do we begin with all of this? There are two types of external force brain injuries. The first is a closed head brain injury, the second penetrating. A closed brain injury happens when there is a non-penetrating injury to the brain with no break in the skull. Imagine, if you will, your brain is like an egg, and when the head has enough forward or backward force, the egg shakes and that yolk can rupture. This is because the inside of the skull is not perfectly smooth. It has a bunch of little spikes or bony prominences that hold the brain in place. So if the brain is shaken hard enough, it can cause micro injuries to the brain. The second is a penetrating brain injury or open head injury. This is a little bit more obvious. This is when the egg gets cracked open or an object pierces the skull. Where does the challenge arise in these cases? Often, there's no external wound necessary to cause the TBI. We can't see it. The closed head injury we discussed can be extremely subtle, even almost undetectable under any imaging. Do plaintiffs even need to prove any objection for this case? A jury may be looking at someone with no physical evidence, but a doctor's testimony is all it takes to meet that burden of proof. What else causes challenges? You can't deny the claim just because there's a loss of no loss of consciousness. Remember, there isn't always a blow to the head. It's not always something you can see. You only need to shake the egg for it to rupture. It can be very minimal. Also, that damage may not be seen or objective on any imaging. Therefore, it can be difficult to get an IME defense ruling out any TBI as well. Let's look at the two most common imaging tests to try to discover or diagnose a TBI. The first one is an MRI scan, a computed magnetic resonance imaging. This is radio waves and magnets that create the view of the brain. However, the issue again may be that this MRI doesn't always show or can't show the actual damage to the brain. The second is a CAT scan, a computed tomography. This is a series of x-rays that takes detailed views of the brain. While a little bit more detailed, it can detect bleeding and skull fractures. However, we're still presented again with a big issue. The micro injuries I discussed earlier from the brain rubbing against the sharp bones is not always detectable even with this type of imaging. And this creates limits of diagnostic medicine. This means you may not have an MRI or a CT scan that shows any objective injury. This is a tremendous obstacle for defense. I'm presented with an obstacle that I can't compare an old image to a new image to determine if there actually is any trauma. This really weakens the defense based on objective evidence and means we are trying to convince a jury with zero objective evidence that a plaintiff does not have a TBI, which is really quite difficult. So with no objective testing, we question how mild is the injury that is undetectable? Should that mean it does not qualify as an injury? But as I previously stated, a claims specialist or defense counsel can't think this way. With all this gray matter, Alyssa, tell us how we can defend these claims.
Hi, thank you, Alicia. Can you hear me?
Absolutely.
All right, wonderful. And I'm going to pick it up from there and really talk about, what happens when you get this type of case that Alicia just described, the mild traumatic brain injury or the brain injury or insult that really has none of that objective medical evidence. And really where I want to start is as much information gathering as you possibly can do is crucial when you get one of these cases. And hopefully you're getting it at the litigation stage. So preserving and developing the objective evidence is really important. And when you're doing that, what are you doing it with an eye for? You're doing with an eye for biomechanical information, and that includes information about how the accident occurred. What were the forces that were acting on the plaintiff that allegedly caused this shifting within the brain, and how could it have occurred? And preserving that information for your experts or for the jury later on is critical. You're also looking with an eye towards what are the inconsistent or the consistent statements and actions, either from the plaintiff, the claimant, or the witnesses and that type of thing. So that's really what you want to be looking for when you're evaluating one of these cases that comes across your desk. I generally like to split my cases up into 3 different phases. The first is when the accident occurred. That's the 24 hours kind of before or after that accident. Then it's the pre-accident evidence. What was happening with the plaintiff before? And then the post-accident evidence. How was their treatment? How are they progressing? And starting with the contemporaneous or the near contemporaneous evidence that you are looking at. That includes, your police report, body cam footage. That type of evidence disappears the fastest, we generally find. That's because memories fade, witnesses become unavailable, videos, photographs are getting deleted. So it's critical to preserve that evidence immediately. Not included on this list also is, security footage. Where did this incident occur? Do I need to be looking at possible security footage? EDR is the event data recorder. In these vehicles, if we're dealing with a low velocity impact motor vehicle accident, is that evidence preserved? Where is it? Where is the cars? Where are the cars involved? And that's the type of stuff you really want to try to preserve right away because it disappears quickly. I also include in that the emergency room records. That's critical contemporaneous information. In the emergency room, they're dealing with the urgency of the injury and the necessity of the treatment. They're objective. Sometimes it's the most objective information or treatment that this plaintiff or claimant is going to get. They haven't gone to the attorney at this point. They aren't being referred different places. They're in the emergency room. The statements they make there, what's included in that, specifically, was there a loss of consciousness that's alleged, is really critical to preserve and just develop, to really understand what's going on in the case. Then you want to look at your pre-accident evidence. What can I do to kind of learn about my plaintiff or my claimant? Sometimes that's just a social media search. If you can get your prior medical records, that's invaluable. Researching prior lawsuits and testimony can be important as well. Where does this individual live? Check your court dockets. Sometimes there's prior personal injury cases. I've been able to get deposition transcripts from prior cases that have proved to be very enlightening. So all of that, you want to think, what do I want? What can I preserve? Or what's the objective evidence I can get to paint the picture I need when I am going to be in front of that jury? And then you go to your post-accident evidence, really, and that's your medical treatment, the evolving complaints that the plaintiff or the claimant has. How did those complaints evolve, and what's the time frame? Were they a few weeks after the accident? Were they months after the accident? Is this a situation where a year after the alleged incident, your claimant or plaintiff is saying, oh, now I need reading glasses or a hearing aid, but they're also, 75 or 80 years old. What are the causal connections that I can draw in terms of those evolving complaints? And then also comparing and contrasting them with the pre-accident medical records. Included in that is, what were the treatment recommendations that this individual got? A lot of times there's referrals to speech language pathology, occupational therapy, physical therapy. And I find that oftentimes in these cases with these subjective complaints, these individuals aren't necessarily following all those therapies to their natural end, or to get the best outcome that they can. I think that's very telling in terms of the fact that these therapies are specifically tailored to some of these alleged brain injuries that they might be complaining about. They certainly should be getting the therapies if they've been referred there. You also then want to look at the neuropsychiatric evaluation, evaluate if the plaintiff's attorney has requested that. And then critical in those evaluations is the raw data. So in the neuropsych evaluation, and Dr. Schutte is going to really elaborate, he's obviously the expert in terms of those evaluations. There's a lot of raw data that's collected that then the neuropsychologist is interpreting and coming up with their diagnosis or their opinions. So getting the raw data for your own expert to look at, for you to evaluate, is really important. You'll find that they don't usually want to give that up, but it's important to try and get it. And then, so your case gets filed, finally. You're getting it to the attorney, and the attorney is doing a lot of the same stuff that hopefully has already been done. Do I have all the documents? Do I have all that objective evidence that I can gather from the accident, before, after? What FOIA requests do I need to make? I personally like to do an immediate internet search of my plaintiff, know their age, know what you can, gather the information so you have an idea of where you're going to go. And right away, you want to start tailoring some of your discovery requests that you're going to be making. In Michigan, you can't serve your interrogatories until after initial disclosures now, and we're limited to 20. So, I'm always a big proponent of being very creative in the 20 that you get. Wasting an interrogatory on what's your date of birth that you're going to get medical records for, and you're going to know that, is really a waste of time. So you really want to be very judicious in how you're writing your discovery requests and use them to the best of your ability. And you want to get authorizations for medical employment records, and I would include in that education records, because we are dealing with a brain injury, so educational history is important. I also recommend, in a lot of my cases, doing social media sweeps. There's companies that provide those. Sometimes they're usually only about under $500 to get an organization to do a social media sweep of your plaintiff. And that can be helpful just in case you missed anything. Surveillance is another big tool that we have in these cases. I know that oftentimes it's not as rewarding as you would hope. The risk of not doing it, though, usually outweighs the risk of, unfortunately not being able to catch them, riding a bike or anything like that. And you want to contemplate where and when you want that surveillance to occur. Do you want to get more information in the plaintiff's deposition to find out where they're going and things like that? Do you want to have a bit of the element of surprise and do it early on in your case? That's really a case-by-case evaluation. Lost wage claims, really just doing your, again, due diligence with the type of work and what we can bring forward to kind of support or refute those claims. You also right away want to consider the experts that are going to be used down the road at trial. And this is just kind of a list of what I would call the usual suspects in these cases. In Michigan, you have to have the licensed allopathic and osteopathic physician to say there's a possible brain injury. So that's usually the neurologist or somebody like that, but they're not usually following up long-term with the neurologist. So that's something to look for. The neuropsychologist, they're really evaluating the complaints of, hey, I just don't feel the same, and those are the subjective complaints you get with these plaintiffs. I have memory or word finding issues. There's some confusion. So the neuropsychologist is oftentimes the expert you're dealing with in these cases, and Dr. Schutte will talk about that. Psychiatrist is really the depression and anxiety. Be sure you know if there's any type of history of mental illness. A lot of times individuals will have had depression or anxiety issues prior to this alleged injury. The ENT, ears, nose, and throat physician, usually hearing issues, visual issues are related to some of these. Physical medicine rehabilitation, that's going to be your therapist. Audiologist is kind of new. A lot of times you're getting tinnitus claims. Ringing in the ears, hearing loss after one of these accidents is another subjective complaint that we see. An ophthalmologist you may have to consider if they're claiming significant vertigo or floaters in the eyes or things like that, and they're relating it to this accident. The last three are a little bit more in terms of your really significant brain injury case where you're talking lifetime care and things like that, but worth being on the list and considering. Outside of the medical and the damages experts, you also, you want to consider your accident reconstructionist and your biomechanical experts. Is there a lot of diversity or opposing opinions as to how this accident occurred? And if there are, in terms of the damages, the low velocity, things like that, you may want to consider getting somebody on board right away. Again, preserving that objective evidence about the accident is important for this stage. And you also want to evaluate plaintiffs' experts under your 702 factors. Do I have a motion for summary disposition or a Daubert motion or motion in limine? Are plaintiffs' experts kind of staying in their lane with their testimony, or are their opinions really going outside of what they're qualified to opine upon? You want to evaluate that early on and kind of get a roadmap for yourself. And then you want to pick the right defense experts, evaluate the medical records. Matching or exceeding plaintiffs' experts, that's again a case-by-case basis. You really want to know what they're alleging and get a better idea of your case. I find that finding an expert that really fits your venue and the case specifically is a really important consideration. Do I value qualifications on paper on a CV more than I do an expert that's very relatable, and I think is in this jury pool is going to be the most useful for me? So it's really important to take that into consideration when you're picking your experts and getting them together early. The neuropsychology evaluation is very subjective, and Dr. Schutte is going to talk on this a lot more, so I won't say much here. But just so the audience is aware, there is a lot of room for potential bias in these cases. Memory, executive functioning, general reasoning are very vague kind of ideas sometimes. But within these evaluations are validity measures that help to avoid any plaintiff that might be trying to skew the findings or the data. It's important to talk to your expert, understand those validity measures, and really evaluate them. Then you're going to get into the deposition of plaintiff, and that's obviously going to be a very important conversation that you have with the plaintiff. Nowadays, it's important to consider whether you're going to do it in person or you're going to do it remotely. I am a large proponent of doing at least the plaintiff's deposition in person. I want to see how the plaintiff is acting. I want to see how they're interacting with their attorney. I want to see how they're interacting with the court reporter when we're off the record. There's just so much that you can gather from being face to face with that individual for a long time, and so many things that come up organically during these depositions when they are in person, that it's really pretty invaluable. You also, in these cases, because of a lot of the complaints are having personality changes, who knows this person the best? Am I deposing family members and or the spouse right away? Sometimes waiting until after the deposition allows them to look at the plaintiff's deposition testimony that recently came up in a case, and then you're going to get a parrot back of exactly what that deposition was. Do you want to do it at the same time as plaintiff and see if they're on the same page? Are they talking about the same issues? Is plaintiff saying, oh, I can't remember anything, but that's not an issue that their spouses have recognized in them? So that's really important. And also asking the question about if there's anyone else that plaintiff knows that would be able to talk about these subjective complaints. Who in your life is seeing the confusion that you're alleging you have? Who in your life is seeing these type of mood or personality changes, and really getting a list of those individuals? It's really one of the most objective, the best objective data we can really get about whether these are valid complaints that the plaintiff has, if family members and friends and employers are recognizing it as well. And then also talk about any prior injuries. did they play rugby when they were in college and had, 10 concussions? Just getting that information out is important. And lastly here, the deposition of the plaintiff's expert. And I'm just going to kind of stop it here instead of going, obviously you're heading towards trial. But the plaintiff's expert, you really want to know the key answers that you think you can obtain from that expert before you sit down with them. A lot of times you aren't going to get that smoking gun Perry Mason moment. Get the concessions that you can and then move on. Know your medical terminology in the records. A lot of times these individuals might not know the medical record as good as you do. So being able to refer back to it, the complaints plaintiff had or didn't have to one physician versus another are all important to have in your back pocket before you walk into those depositions. And with that, I think we're turning to the Q&A with Dr. Schutte, our expert neuropsychologist. I will briefly introduce Dr. Schutte. Dr. Schutte is a licensed neuropsychologist certified with the American Board of Clinical Neuropsychology. He served several years as the manager of neuropsychology at Henry Ford Health and is now with Corewell Health. And he operates comprehensive neuropsychology and conducts these type of neuropsychological evaluations, including specifically for the patients and the plaintiffs that we're talking about here today with the alleged mild traumatic brain injury in the setting of personal injury litigation. And so Dr. Schutte, I don't know if he's with us yet, but if he has anything he'd like to add about his background, I'll go ahead and leave it to him. Doctor, how are you?
Good. How are you?
I'm well. I'm well.
Just inviting everyone to turn on their cameras and to remind the audience that if you want to ask a question, please type it into the questions window on your webinar dashboard. We'll give you a few moments to do that. And now, if we could, do we have anything in the? Okay, we could probably break the ice with this and say, Dr. Schutte, under the circumstances that we usually see, we'd like for you to be able to conduct the examination without a third-party observer. When that is court mandated, is there a strategy to use the plaintiff's neuropsychologist's raw data and rescore that for a different report?
Yeah, that's actually one of the ways that I can think of dealing with this situation, is that I could do, say, the interview, and there's no contraindication really to having someone be present for the interview. I've always allowed other people to be present during the interview, including the plaintiff attorney if that's what they want, so they can record that if they would like. And then I could always get the data from someone else. In general, that'll work reasonably well. There are a number of people who probably do the bulk of plaintiff-oriented neuropsychological evaluations whose their test battery is fine, the technicians do adequate work, and so that would be fine. There are a few people out there who don't do that, but that would also allow me to take a close look at what they actually did and offer a good critique of what happened. Like there's one place in particular that's doing them online, which is not an adequate approach. And so, if we get that kind of data, I wouldn't think that that's particularly meaningful data, but it would still be really worth critiquing and pointing out.
Wonderful. And doctor, just briefly, in terms of your role, or how do you generally view your role in these cases, what we describe the mild traumatic brain injury without the objective evidence, and with these type of patients?
Personally, I see my role as being objective. There's just a difference between the kind of model of being a medical provider and I think being an attorney. An attorney, you're an advocate, and that's what your job is. For me, my role is diagnosing whatever it is and being flat and even about it. And I think that's been my experience, is that most of the people that I've worked with, that's what they want as well. And so my approach to it is to be as objective as possible, to follow the research, to be able to document down what the research is, and then take a look at someone's objective performance on testing and see what that's most consistent with. I mean, when you're asking about something like mild traumatic brain injury, or probably more appropriately call it concussion, though I mean, it's an interchangeable term. The research is that people just get better from that. And so the likelihood that you're going to have any findings is exceedingly low to nil. A person's presentation is likely something else. And that's true when I see people in the hospital or I see people otherwise. It doesn't matter whether it's an auto accident or if they had a fall. If you're having ongoing symptoms that you are relating to having a concussion far after the fact, there just really is not research support that that's what's going on. Now, a lot of the complaints that a person may have are pretty subjective and they're non-specific. So, I mean, a person says that they have problems with concentration, and we see it all the time for a variety of different diagnoses. So we're currently seeing it for people having complaints of, say, long COVID, which there's really no support that that's a thing. And so, but that's what they're concerned about. Or the number of people who present with what they think are symptoms of ADHD, and they say, look, I looked it up and here's all these symptoms. These are all me. I must have ADHD. And it just turns out that those kinds of problems happen for a lot of different reasons. A person could even be being honest about it. And they say, I have these concentration problems. I think that I'm not able to function anymore. I'm having brain fog, things like that. And it could easily be because a person's anxious, or it could easily be because a person is depressed. Or the definition of migraine by neurology is very broad and includes almost every headache that you could have. And so the likelihood is that if you go to neurology, you're going to be diagnosed with migraine. And then in all likelihood, because they see an association between migraine and in some ways how seizure disorder is activated, they'll often put someone on anti-epileptic like Topamax. Well, it turns out that causes cognitive difficulties. And so a person may come in and say, I'm having concentration problems. I don't think I can think as effectively. I feel distracted and slow. Yeah, you probably are, because you're on Topamax. That's why they call it Topamax.
After the skeptical brain injury or no blow to the head circumstance, the diffuse axonal injury, how do you address that, and what should we be looking for to evaluate the patient's condition?
So key to this is that the symptomatic presentation is not very meaningful. But this is true of many different kinds of medical diagnoses. The symptomatic presentation means that a person's distressed. They may be experiencing a set of symptoms. It does not tell you what the etiology or the cause is. And I think that we have a lot of medical providers that are treating it that way. All a person has to do is to come in and say, I had an event, now I feel like I can't concentrate, and their reasoning goes as far as, I don't know, you said you can't concentrate, it's different than it was before, you had this event, must be because of that event. And that's as far as their thinking goes. In terms of traumatic brain injury, what you're looking for are the injury characteristics at the time. It's how your body responds to that event. So you're looking for loss of consciousness, but more importantly, length of loss of consciousness, length of what's called post-traumatic amnesia. That is not a period of time. So people start using, and I've seen it in a lot of medical reports, they're using a person's conversational use of the term, something like, I have problems with, it was confusing to me. I was confused after the accident, or I felt dazed. That's not what the criteria for concussion is about. So it is true that part of the criteria for that is an alteration in a person's level of consciousness. It does not mean I was involved in an accident, there's a lot of stuff going on, so it was confusing to me. That's not what it's talking about, but you're going to see that repeated in multiple different kinds of reports where someone says they said they were confused, so they had an alteration in consciousness. That's consistent with a concussion, and therefore that's what I think is going on, right? That is not what the American Congress of Rehabilitation Medicine defines as alteration in consciousness. They're talking about you're literally disoriented. So like alert and oriented times two, you don't know where you are, or you're not aware of what's even going on. or you can't even follow two-step commands like, can you take this pen and drop it? You can't follow two-step commands. They're talking about literal confusion. So you're looking at loss of consciousness, length of loss of consciousness, a confusional state, and then imaging of the brain. So diffuse axonal injury is what we think is going on with traumatic brain injury, but that's what we think is going on with moderate to severe traumatic brain injury. That is not what's going on with concussion. Concussion probably doesn't cause any tissue damage at all. So you can have some pretty mild symptoms after a concussion. A person has a legitimate concussion. There is a chemical cascade of things that happen afterwards, so you really can feel just a little off, little kind of like not totally with it. That's known to resolve within days to weeks. 3 months at the latest. At 1 year, so the World Health Organization, this is old now, the World Health Organization did a meta-analysis on traumatic brain injury literature. It's 2004. What they found is that at 1 year, the only predictor of having ongoing symptoms from a concussion is your litigation status. And so the reality is that a person can really experience some symptoms right after, and they'll go away. Sometimes you can get people who are reporting symptoms at 1 year, and assessment of performance and symptom validity are incredibly important to my field. But I often like to talk about things like this, a person who's being forthright and they're really concerned about it. There can be kind of a crossover where your symptoms from the concussion went away, but at the same time you have concomitant anxiety. And so you start attributing problems with concentration that you're now experiencing to this concussion, when in actuality at this point it's because of your anxiety. And so people who are being forthright, sometimes they're reporting these things. They legitimately think that that's what's going on, especially because you have a number of providers who are reinforcing that for them. Not consistent with research, not consistent with what we know about this, but they're reinforcing it. So they may perceive that that's what's going on and it's related to something else. So to answer your question about diffuse axonal injury and traumatic brain injury, diffuse axonal injury, you're really looking at moderate to severe injury. So what that is that you have your neuron, kind of like your processing unit. There's a wire coming off of that. It's called the axon. That's covered in fat. It's called myelin. So what we think is going on with traumatic brain injury is moderate to severe brain injury, is that the force of the collision or whatever it was that you had tears those. And as a result, the person's thinking is a little bit less efficient. And that's what happens not exactly, but affecting the white matter of the brain happens in a variety of different disorders, like vascular disease as a person's aging, or multiple sclerosis. They all attack white matter. But that's what's happening in diffuse axonal injury. So people will typically have problems more with like attention, how fast they do things. That's really what you're seeing, but not in concussion. That'll just resolve out.
Can you also explain to us what we should be looking for, or what would be the typical treatment of an injury like that?
The research-supported treatment is like 5 minutes in the ER saying, you're going to feel a little goofy for a little while, get some rest, you'll be better. That's the research-supported treatment. The other supported treatment would be if a person is maintaining those symptoms for an extended period of time that's beyond expectation, would be psychotherapy. And the psychotherapy would look very much like treatment for a somatic symptom disorder. So in other words, people who legitimately, truly believe that they have something wrong with their body and there's just no objective evidence that's true, then you would work with them on kind of getting past that, re-engaging in activity, showing them through their engagement that that's not really what's going on here. Because challenging that person and telling someone, you don't really, the back pain that you're reporting isn't objectively present and it's not really there, they're going to reject you and say, of course it is, I'm in a lot of pain. The way that you would do that is to work with a person about, well, okay, I'm not going to argue with you about how much pain you're in. You're in pain. So let's start re-engaging in some activities and get you a little bit back to enjoying your life some. And then over the course of that time, showing them, see, you're able to do all these things that you said that you didn't think you were able to do. And treatment for what's really what we think of as more of a psychological problem, the post-concussive syndrome, that's more of a psychological problem. That's what you would do with that treatment. Unfortunately, what we see a lot of is providers who are instead telling people, or even in some cases like speech therapists, having a goal of a person accepting how impaired they are, which is beyond me why anyone would do that, but that's part of what they do.
Is there anything in medical records that us as attorneys or even the claims specialists, when they first receive a claim, that they should really be looking for that kind of triggers, this is something I should really be taking serious, or this is something I should watch closely?
Injury characteristics at the time. That is what's predictive of outcome, not a person's symptomatic presentation. So injury characteristics at the time, and so loss of consciousness, length of loss of consciousness, period of what's called post-traumatic amnesia, and imaging findings. So if you're finding someone who gets into an automobile accident, gets knocked out, they present to the emergency department with a GCS of 8, they have a week of confusion, and you can see that in the records where they're saying this person's alert and oriented ×1 for an extended period of time. They do some imaging of the brain and they show a subarachnoid bleed or something like that. That person probably had a legitimate severe brain injury. And you should expect from there the person probably is going to need some inpatient rehabilitation. They are going to get a bevy of therapies, and this is probably appropriate. And then at some point you need to start assessing out where are they really at cognitively. So in terms of the injuries, that's what you want to know. You want to be able to frame in, I think for adjusters and for attorneys and for medical providers, you want to frame in, what do I know about the injury or the disease or the disorder that someone has? What are the known expectations of that in research? And if it starts falling way outside of that, well, something else is happening here. Either some providers are offering treatments that are maybe too much and they're benefiting from that, which unfortunately happens a lot, or the person's got some other kind of problem, or there's some magnification going on and things like that. But you want to have an idea of what was the actual injury, what's the supported treatment for that, and if it starts falling way outside of that, that's where it should start raising some flags. And I'm sure you're also familiar with a number of providers that probably start throwing flags in and of themselves because you don't find yourself to that person unless you happen to have been in an accident. Like, they don't do regular work. That's it.
And what about, doctor, a lot of these cases are coming already at the time that they're filed with the neuropsych evaluation done. When we get that, when you're looking at that evaluation or that report and there's none of this objective finding, we're a year out, what are we looking for in there that we should be questioning or looking into?
It's a little provider specific. I can tell you that what you should be looking for in terms of neuropsychology in general is a good history, detailing out the actual injuries. There are a number of people who will read their reports. They don't even bother talking about whether there was loss of consciousness, how long it was, et cetera, et cetera. And from that perspective, how would you even know what it is that you're evaluating? So it's not so much that neuropsychological data are subjective. They're really not. It's that they're non-specific. You can have those findings for a number of reasons. Like I said, you could have actual diffuse axonal injury, or you could have white matter disease from diffuse vascular dysfunction, which is super common. Or a person could have multiple sclerosis, or they could have medication effects, or they could have an infection. There's all kinds of different things that affect white matter. And so you could have a pretty similar look on testing. So the way that you're going to know the difference between what seems to be causing this is a good history about what's going on here. I think that one of the things that's the strength about what I end up being able to do is often that I have records, and they often don't. And so in a lot of cases, they report things that an examinee told them, and it's not consistent with the records at all. So you're just operating on conclusions that are based on information that's just not true. I just had to do a deposition where that was the case. Like, this person told every individual person something else, none of which was consistent with what actually happened. You know, and so in some cases you should be looking at that, like, is what you're reporting, what the neuropsychologist is reporting, is that actually consistent with what actually happened? You certainly want to see evaluations where they're, just because it is standard of practice, most actual neuropsychologists will administer validity measures. There are a few people in the community here that are doing evaluations that don't. That is below standard of practice. I wouldn't treat that evaluation as meaningful in any manner. There would be no way of knowing whether a person is engaged or not. And research about our ability as medical providers, not as neuropsychologists, as any one of us, our ability to identify whether a person is being forthright or not, or whether they're engaging or not, is not good. You need objective testing. And so if you're not seeing objective testing, there are some people who present the data in an unusual way. There are a number of people who use percentiles. There's nothing wrong with using percentiles. In some ways they have a strength, and it has to do with the shapes of distributions of test scores, but they can also bury data in there. So in other words, if I tell you the test scores in percentiles, and say I have someone who had an IQ of 115, like pretty good, standard deviation above the mean, this person probably has a lot of intellectual abilities to do other things. So I say that's a high average score in comparison to age-matched peers. And then I go to the memory testing, but this person has a master's degree. I go to the memory testing and I say, but this person's memory was actually in the average, in the lower end of the average range, like a T of 45 or something like that. And I think that that's a real difference. Well, you're making two totally separate comparisons. One's in comparison to people of that person's age, another one's in comparison to that person's age and education level. Those scores may be the same. You're just skewing it by making those comparisons and changing them over time. And if a person's giving it to you in all percentiles, you wouldn't know. You have no idea what it is that they're comparing to. So those are things that are worth looking at. That's where I would start asking for raw data, so that you can start getting an idea of, like, what were those data actually, what did they actually look like? But by and large, pardon me?
Sorry.
No, go ahead.
Kind of along those lines, so a second neuropsychologist could rescore the testing from the raw data and arrive at a different conclusion. Is that possible?
Yeah, absolutely. Not that reaching a different conclusion is what should happen, but yeah, absolutely. You know, and we'll often see people there are unfortunately people who are treating neuropsychological testing like it's a bowl of spaghetti that you throw at the wall, and whatever sticks on the wall, there's the deficit. It just turns out that that's not true. A good quality neuropsychologist should be looking at it like, there are things that are more and less sensitive to this particular disease or disorder that I think is going on or that I'm evaluating. And I should see a pattern of performance on testing that's more or less consistent with that. And to the degree that it's falling outside of that, well, it's probably not what's going on. If I'm seeing someone for Alzheimer's disease and they're 80, okay, so there's a pretty high likelihood that a person has Alzheimer's disease at 80. At 85, you're 50% likely to have dementia. So pretty good likelihood the person has a dementia process going on. If the testing performance doesn't match the pattern that I know happens in Alzheimer's disease, well, then I'm not going to diagnose that. Maybe it's something else. Could be a vascular problem. Might be nothing. The point is that you should be treating the data more like you're putting together a puzzle. And I know what this puzzle should roughly look like. And my test data should reasonably match that. And so, of course, it's possible that someone has random data and they say, this person's word reading is low, that must be their brain injury. Well, that's not what we know about brain injury, but they could certainly make that conclusion.
And then in terms of continued treatment that you're seeing with the cases that you're dealing with, You talked a little bit about the therapies, but what should we be looking about with the evolving complaints and the therapies that if we do have that brain injury that you're talking the 3 months to a year resolved, what's the treatment process that you would want to see to kind of confirm that diagnosis, if that makes sense?
I wouldn't ever use the treatment to confirm the diagnosis. I would always rely on the beginning. Always go back to the beginning. What was the injury that was actually sustained? I would always want to see that the treatment appears to be at least roughly reasonable. In concussion, you should just have resolution, and I wouldn't expect you shouldn't need any kind of long-term treatment. In moderate to severe brain injury, generally what you're seeing is a recovery over the recovery over the first 3 to 6 months is going to be pretty steep. It's going to be, a really good recovery. That'll start flattening out from like 6 months to a year. At about a year-ish, it's probably going to be pretty plateaued. And in that case, any kind of treatment that you're seeing, at least from a cognitive perspective, should be like learning how to adapt. So one of the problems with a lot of the ongoing treatment is that, I don't know, speech therapists will do some kind of evaluation. They'll say this person's at 85%, whatever 85% means. And well, that person is probably going to be at that point for, forever. And so that doesn't justify ongoing treatment for that unless you're pointing out, like, we're working on this specific thing. It should be practically focused. We're working on this. Because it turns out that doing things like, and this is actually why you remember that luminosity program that they were advertising a ton for a while? The FTC fined them because of false claims. It turns out that stuff doesn't work. You can keep doing a word list over and over and over again, and you will get better at the word list. Your memory has not gotten better. You just got better at that task. People don't generalize that very well, and so good therapy should be focused on practical adaptations. Like, this person is trying to move out from this facility and is going to be living alone. That means that he or she is going to have to manage their own medications. And so we're going to do some occupational therapy that's specifically focused on, here's how you fill a pill minder, here's how you manage it, here's how you assure that you've taken it on time, those kinds of things. That's practical. Yeah, that totally makes sense to me. If what we're doing is, like one of the facilities, we'll literally be doing grocery store games. Like Simon Says, Uno, things like that. It turns out does not work. If you're seeing that kind of documentation, that's just start raising some concerns like, what are you doing? But you want to see people documenting that we're working on functional abilities.
All right, Doctor, I don't know, do we have any questions, Alicia, in the queue? I know we're getting to 5 minutes out here.
I do not see any more than I've asked. If anybody has any final questions for the doctor.
No, I think that's been a really good overview in my opinion, and I don't see that we have anything else.
I'll just add in that, one, always question the premise, because in a lot of cases you're seeing people offer diagnoses that are based on essentially nothing, or diagnoses that are based on incorrect information, and it matters. They're offering diagnosis. Sometimes I'm sure that there are treatment providers who are honestly offering a diagnosis and they're just wrong. In some cases, it's just sloppiness. In some cases, it's probably other things. But question the premise as to what's going on. In the same way, it just turns out that some medical fields, they've got a hammer, so everything's a nail. So like the definition, like I was saying, the definition of a migraine is almost everything. It's a person who has had 5 or more headaches that last between 4 and 72 hours without treatment, and they have 2 of the following, which can just include moderately to severe headache, and that it's throbbing, and if you have a little bit of nausea with that, that's migraine. And so then they step from there to what seems to be causing it. Well, it's in the brain. That's related to the fifth cranial nerve, and then the vasculature coming from that, and that there's some relationship between that and seizure, and et cetera. And we do the same thing with ADHD. The diagnosis for ADHD is entirely based on behavioral presentation. So in some cases, I'm sure that a child has an actual difficulty with attending, and we think it's because of white matter change, like they haven't developed enough in white matter. But I'd say most of the kids that I see, it's parenting issues and environment. So you're making this step from these kinds of diagnoses, and then we see just a lot. You're making the step from there to, and it's neurologically related. Or you came in because of this event, therefore it must be because of this event. Which that kind of reasoning is silly. You end up with bad diagnoses, you end up with hurting people. And what we do as medical providers, we can make people worse. It's not just cutting off the wrong limb. It's you can get a person to start engaging in a lifestyle that they will never get out of. By the time, that's the thing that it's just the toughest for me is a person's 5 years into doing this. What are you going to do at this point? That's going to be to right this ship is going to be very, very hard. And so, we can make people worse. And so always question why it is that someone's reaching that diagnosis. So, a lot of us, hospitals have us set up with like 15-minute appointments. We don't for neuropsychology, but a lot of medical providers, that's all they've got. They don't have time to look in records. They just like, whatever you told me. If you go into the emergency department tomorrow and you tell them, and they don't have records on you, and you say, I have a history of brain injury and seizure disorder, well, they're going to document this person with a history of brain injury and seizure disorder. Yep. And so you always have to take a second look at those things because that's commonly the case. And then that makes that diagnosis. Henry Ford offered a diagnosis of seizure disorder and traumatic brain injury. It's because you told him that you had that. So you always have to look at those things.
For sure. And thank you, doctor. It's very useful. We come across that and looking at medical records all the time. I like to call it telephone. It's going to follow and you're never going to get it out of that medical record. And so,
and it's often a big fish story. It starts from here. And then as it goes on over the course of a year or 2 years, it turns into, I was in a coma for a week and whatever. Yeah. I would fill in quickly. One of the other things that you want to look for in terms of brain injury is if a person was intubated and sedated for another reason right at the time of the injury. Mm-hmm. So they may go and tell someone, I was in a coma for 4 days. That may be true. It's because you had pelvic ring fractures and they knew that they were going to be bringing you in and out of the operating room a lot, so they just kept you out. Or person had a very high blood alcohol level, so they just intubate and sedate because they're going to try and back you out of that and giving like benzodiazepines, and this person was agitated and so on. That's true, you were unconscious for 2 days, but it wasn't because of a brain injury. So you often have to look for that. That is often a complication in the records that I see, where a person then goes and tells some outpatient neurologist who has no access to the medical record, I was in a coma for 3 days, and the neurologist says, well, it sounds like a severe brain injury then. Yeah. And it turns out that's just not accurate. That's not what happened. Mm-hmm.
Doctor, we'd like to take this opportunity to thank you for your time today. We're prepared to go off camera now and go forward. We do have a survey that we're going to ask you to fill out and ask our audience to fill out and take a few moments just to complete it. The reason for that survey is it gives us a tremendous amount of information about how we assess these programs, what value they have, and how we can take that information and build a better webinar for the next time. More generally, if you're interested in learning more about general liability matters, please visit the Plunkett Cooney website, plunkettcooney.com. You'll find our Litigation Defenders blog, which focuses on the latest general liability case law, legal updates, and news. Likewise, if you or a colleague would like to access today's session, we have a recording on the website as well as the corresponding presentation slides, so you can obtain them by visiting the event page on the FIRB's website.
The two links are at the bottom of the event page. And that concludes today's webinar. On behalf of Alicia, Alyssa, and Dr. Schutte and myself, thank you once again for attending and have a great rest of the day.